factors under B, under here, under the context of fee arbitrations. You need to balance the problems in obtaining the fair hearing, which are time limitations, the various abilities of the parties, and side issues, which I'll get to in a minute. But you need to balance those against the requirement that they obtain a fair and full hearing. The ability of the counsel and parties, back to the time limitations just briefly, you can grant more time. I don't know how much you'll have to do that. Most of the hearings we have done have been conducted within an hour and a half, but I think it really depends, again, on the arbitrators controlling the pace of the evidence and what is admitted within the context of granting the fair hearing. The problem with the ability of the counsel and the parties, the problem with parties that are representing themselves, particularly clients, is that they are not as adept at presenting evidence as the attorneys are. There are many times I think the arbitrators have to go out and help obtain that evidence, help get the facts out, but at the same time maintain the impartiality and make it appear that you're just trying to get information as opposed to actually take on an active role in representing the unrepresented party. And I think it's a difficult balance, but I think you have to be active. If the attorney comes up and presents all of his materials and the client does a poor job of cross-examining, but you have questions within the fee agreement itself or within the time that's spent, I think you should ask those questions so that you feel that you're reaching a fair result and making a fair determination of whether this is a reasonable fee. It does come up a fair amount, and I think you have to be focused on that, but also consider, as I say, that you do not appear to be representing the party and antagonize the attorneys to the point where they will never again participate in this process because they think it's somehow just a client-oriented experiment that's there to protect the clients. Under side issues, you end up with side issues that are not fee-related. David went through and did a bunch of the fee issues, but what you end up hearing in a lot of these hearings are issues which aren't directly fee-related. They may be malpractice-related. Sometimes the clients come in and say, well, I talked to my neighbor, and my neighbor says I should have gotten, twice as much, and maybe the attorney didn't do a good job. Well, you have to be very careful when you get into something like malpractice or neglect. You hear a lot of complaints about neglect. My attorney charged me all this money, but I could never get a hold of him, and the complaints turn out to be more along the lines that there were no lines of communication or that the client was neglected. These are generally side issues, which again, you have to try to exclude to the extent possible. The side issues, unfortunately, can come back through under Rule 1.5. There are instances in Rule 1.5 where it talks about things like the results that are obtained, time limitations, whether the basis of the fee was properly disclosed to the client, where you end up in some areas where it's kind of is a fee issue and kind of is not. And again, you have to do a balancing and use your best judgment as to whether those side issues are relevant to the inquiry at hand. All right, the procedural issues in the hearing itself. It's kind of difficult to separate the procedural from the substantive, but here we go. Pre-arbitration conduct. For the most part, this process was designed to give you a case that was ready to go at the time you take it. The judges have already held hearings. They've already gotten the parties to provide the fee petitions and whatever responses there may be to the fee petitions. So this should be ready for you to go, and you will get that package of materials. And it's very important that you review these materials and be familiar with them before you go to the arbitration hearing to make sure that there's enough time to go forward on this. The conference among arbitrators. Once you go to the arbitration hearing, you've reviewed the materials. I think before you open up the hearing, before you have the parties into the arbitration room, you should discuss the case a small amount. You shouldn't be deciding the case, but you should go over with the other arbitrators what you feel the issues were at the time you reviewed this. Whether it's an issue as to the amount of time the attorney spent briefing issues, whether it was too many inter-office conferences, what are the specific complaints raised by the clients, or what issues you feel will be the important issues in this hearing. And you do this so that you can prepare for the hearing and prepare to know who should go forward in the hearing, who should present, what types of evidences you might want from the parties, what you might want as far as opening statements. Maybe you don't need an opening statement. These rules were drafted very broadly to allow you to have leeway in running this hearing. You will run this hearing. There's no set limits as far as time, for each side gets a half hour and a half hour of rebuttal. It's all up to the arbitrators to pick, based on the specific case that's in front of them, how they want to operate that hearing. And therefore, I think you should have a conference between the arbitrators to discuss these matters. And at this point, I would also note that the rules, I believe it's the rules, or maybe it's the agreement, requires that the chair of the committee be the matrimonial law attorney. I think we need a chair. We need somebody to be sort of the point man, but I don't think the other arbitrators need to be overly deferential to the chair. I think they should speak all with a similar and same strength voice as the chair, but the chair just sort of has the point position for purposes of going forward. But I think all the arbitrators need to have input regarding the conduct of the hearing and what is received into evidence. All right, so once you've had that conference and discussed this briefly, you go on and bring in the parties and begin with the hearing itself. At this point, I think you should just run through and confirm that the parties signed the agreement, that they're here voluntarily, that they understand what the program is and what the expected results will be. I don't really know that there's any procedure if they say, no, that's not what we wanted to do, but at least they can be aware of, and you're giving them the basis to understand that what they're doing is very serious and that you will be making the decision and that they agreed to that decision. Let's see, under Rule 10, the rule does provide that the arbitration may proceed in the absence of a party. Normally, I would say it's very difficult to do that if the attorney is not present. However, you can take whatever evidence you feel is necessary to make a decision. And the rule allows that, the CBA rule allows that, and you should proceed forward. It should not be an automatic default win for whatever party is there. Again, I think your duty is to determine the reasonableness of the fee and take evidence and do what you feel is necessary to make that determination. You probably have written documents from one of the parties. If they're not there, you know what their position are, and you can balance that against the evidence that's presented to you at the time. Waiver of the right to counsel. I think this is fairly important. It's attached, there's a set within the agreement, the Chicago Bar Association agreement to arbitrate. There is a waiver of the right to counsel. I think it's important that they sign this at the time you start. In fact, I think it's required, but it's very important that they sign it, because you don't want anybody coming in after the hearing saying, oh, boy, if I would have known this would have happened, I would have gotten myself an attorney. And believe me, it's happened to us. It's happened to us within the CBA. They don't like where they're going. I've had this one case. It was actually a large business case where a business was sold for a couple $1 million, and the parties that were complaining about the attorney's fees came in and said, well, if we would have known this would have happened, that they were going to present evidence like this, that they were going to have these documents, that they were going to show up with an expert witness, we wouldn't have come into this alone and unprepared. We would have had our attorney. And they try to avoid the outcome or avoid the result, and that's why it's very important that you get this waiver signed and make it absolutely clear to them that you will proceed. They have the right to counsel. I think if they say we want to have counsel, I think you take that opportunity, begrudgingly probably, but you take that opportunity to reset it. Otherwise, I think it could fall within the Uniform Act and could be something they might be able to get out of the result if you go forward. Next, I think you should go through, the chair or somebody the chair designates should go through and give both parties a statement of what is going to happen here. And it should be fairly simple, but it should outline the procedures of what the parties should expect. And sometimes I've seen these, the NASD has these actually scripted for the arbitrators, and it's very formal, and they must read this type of opening statement. We don't need anything here like that, but I think you need to tell the parties whether there's going to be an opening statement, what order they're going to proceed. The order doesn't have to be that the attorney goes forward first and then rebuttal by the client. If it looks like there's very specific issues that the client has raised within the written materials you've received and has specific complaints, there's no reason why you can't let the client go first with a complaint on their issues and then have the rest of the hearing. So you set forth that order at that time. That does not, however, let me just go back and say, if you decide that the client goes forward, that does not relieve the attorney's burden to prove his fees. That only is just a choice in how you arbitrators want to proceed with the hearing itself, and not any kind of evidentiary or other substantive effect of that ruling on how you go forward. It just allows you to organize the direction your hearing is going to go. You may wish, after the evidence is presented, to have them explain to them they have the right to cross-examine and to call their own witnesses, and then you may decide that you can have a closing argument or not, again depending on how you feel, but you go ahead and do that at the beginning. Under D, I have housekeeping. By this I generally mean you should probably at the beginning to determine how long this will take and how much time is necessary to find out how many witnesses people are planning on calling, how many exhibits might be marked and offered as evidence, and any other issues like that to help you streamline this proceeding, because you do have a limited amount of time. Swearing of the witnesses, that's pretty obvious, but you wouldn't believe some people forget that. And you may want to swear them as a group. If somebody wants to exclude witnesses, that's up to your best judgment whether they can exclude a witness that is not a party, and just make a ruling with that at that time. All right, now you're past that, you go into the hearing, and I have 4 topics here: focus, time management, evidentiary concerns, and sufficiency of evidence. Focus and time management are really related. You want to get to the fee issues, but you want to keep the parties focused on that. You don't want them to keep complaining that my attorney neglected me this entire period. At some point, you have to keep them focused. This is a fee dispute only. We cannot rule on any other issues. We cannot rule on any complaints that they violated any other rules of ethical conduct for attorneys, or that they committed malpractice or anything else. So you need to keep them consistently focused and consistently moving down that path. And let me just, under time management, there's a couple areas where I think you should be careful. Sometimes parties inadvertently waste time. They're used to having longer hearings. They're used to having a long time to cross-examine. You don't have that time. Please help them move along wherever possible. You can say, we understand this, we've read this, we understand this, we've heard this 3 times before, you can move on now. And sometimes it's inadvertent, but unfortunately sometimes it's calculated. And I've been in hearings where it's definitely appeared to me that one or both of the parties are dragging their feet, trying to eat up the clock for the other side. You have to be very careful of that and keep everybody moving along. Under evidentiary concerns, this program is also designed to be within your discretion, and you may pick the type of evidence you hear and judge the relevance and materiality of the evidence. That's under Rule 11. A lot of times in these hearings you get hearsay. You can accept that if you want and give it the weight that it's worth. Many of you know sort of what that means, but when you have evidence that's hearsay that would not normally be admissible, you can accept that in, but discount it later when you go to decide what the reasonable fee was in the case. But I think here the rule is written broadly to allow you to take in as much evidence as you can to reach the fair result. On the sufficiency of evidence, again, if you need more information from the parties, don't be afraid to ask questions. I've had people challenge my authority and say, you're not supposed to ask that, or that's improper, or you're doing something for them. I think you as arbitrators need to feel comfortable with what your result will be. And if something is missing, if there's no explanation of why a brief took 8 hours to write on an easy issue, ask that question. If the client is unreasonable and asserts that they shouldn't have to pay $150 an hour when that was what the contract is, go ahead and explore that if the attorney hasn't already done so. You may also request the additional documentation under Rule 11. As I believe Linda said, it should be rare, but it is possible. Sometimes I've seen cases where it becomes an issue as to whether payments were actually made and received. The client has incomplete records and the attorney has incomplete records, and sometimes it's necessary to say, provide me with copies of check stubs or something to show what is actually left owing. So it's okay to ask for that if you must. Assign a deadline date that's an absolute deadline, and then plan for a ruling after that. Under substantive issues, David did a great job. I don't really have much to add from what I've said. I did note he mentioned a couple of areas, minimum charges and travel time. These are real common, and be aware of them. Some fee agreements say I will have a minimum 0.4, 0.5 charge for anything I touch. And if all you're doing is calling somebody and leaving a voice message for a minute, that shouldn't be billed out at 4/10 of an hour, even though I have seen it done within the context of matrimonial cases. And just because the fee agreement says that, I think you need to probe Rule 1.5b, where it talks about the basis of the rate of the fee shall be communicated, to make sure the client understood that that is what they were undertaking, and even then you may decide it's not reasonable under the circumstances. Travel time is also another problem. You do get attorneys either driving from the loop out or from outlying areas into the loop. They charge full travel time on that. I would be very careful with that. You might also have another area that David did not mention. We have a lot of churning that I've noticed in some of these cases, where you have churning of the file, not really churning fees, but of the file itself. You get some attorneys, they have new associates every 6 months or a year, and the case has been pending for 2 years, and every time a new associate comes on, there's another 4 or 5 hours reviewing that file. Or, worse, it's hidden in some other way, but it's still in there. There's a lot of excessive time based on new attorneys coming into the case. I'd be very careful with that one. Other than that, I think David did a great job. He's got a great outline for the specific issues, and thank you for your time.
Thank you, Eddie, very much. I know these presentations were very thorough, but I'm sure that there are some questions remaining out there, so why don't we take an opportunity to address those? Yes?
Somebody selects mediation, fails. Why can't they then say, well, now we want arbitration?
The question is, if someone initially selects mediation and it's not successful, why can't they then select arbitration? They can then select arbitration. There's nothing preventing that. Yes?
This is actually Judge Evans. Monday is the matrimonial law committee meeting. Can I make an announcement Monday and what the target dates are, or would you prefer that to be held on?
No, go right ahead. In fact, it would be perfectly all right. The target date, of course, is October 1st. And in addition to the training today, there's one additional training session on
Monday.
On Monday.
Right after the matrimonial law.
Yeah, so I think nothing wrong with that at all.
The judges will start entering orders starting October 1. Obviously, the arbitrations won't occur October 1, but they'll occur thereafter. Yes?
I'm concerned about immunity. The Rule 14 purports to create immunity, but Rule 14 and none of the other rules appear to be incorporated in the court orders, the statute, or anything else. So what is the basis for believing that Rule 14 has any effect?
I thought it wasn't. It's not in the arbitration agreement?
No, it's not in the agreement, it's not in the notice, it's not in the order, it's not in anything.
Okay, we will add that to the arbitration agreement then. Yes?
It says that, the judge said that the client has the right to see the time slips, the charges, before an arbitration were to take place. Is that true for mediation?
Yes. Could I just
Sure, please.
This procedure that I'm talking about would take place in court even before they get to the mediators or the arbitrators. They have a right to receive that, the time spent and what it was for. to look it over even before they get to mediation.
Yeah, and to further comment, yeah, the parties will have exchanged the relevant information, and the mediator will also get a packet. So what the mediator gets, the parties will both have, mainly the attorney giving it to their client.
Yes.
Someone alluded to whether what had been recommended, like at a pretrial, for example, that had been rejected, and an attorney decided to press forward and then ultimately get less trial than he was offered already. Is that something that's generally open at arbitration or mediation? What the offer was, is that testimony?
The question is whether or not information or offers and refusals of offers at pretrials should be part of the discussion at the arbitration. David, do you want to handle that?
Yeah, they are relevant, not for the purposes of the settlement, but they are relevant in the case law to demonstrate what the benefit was in going ahead and spending the time in the litigation. Results achieved is also a factor that the courts consider. So to that degree, it would be relevant to look at those factors. But again, be careful with that too, because nobody knows what a court is ultimately going to do, and if a settlement was rejected in good faith, I don't necessarily think the attorney ought to be punished for that. If it becomes a more glaring, obvious thing that they should have settled this case and the lawyer was simply trying to churn the case, then yes, I think the lawyer really suffers on benefit and results achieved.
One other question was, someone also talked about the issue of not getting side issues where clients are complaining about incompetence or other possible ethical violations by their attorney. Is that something that then is excluded? Are there issues that they come up with something like as attorneys participating on these panels? Would we have, there are cases where we might have ethical concerns that we would have to report someone?
The question is if side issues come up that you think may need to be pursued, like ethical issues, what do you do as an arbitrator? Eddie, did you want to address that?
I think that's a great question. I don't have an easy answer for that. I think it depends on how much information you have and what you feel about it. I think as an attorney, if you feel your ethical duties are to report that to the ARDC and you feel you've heard enough information that would allow you to believe that there had been an ethical violation, I think you have a duty to report it. But I think you don't have a duty to delve into it at the hearing, and I think you can say, we're not here really to hear neglect. Once the client goes into areas that are side issues that might be neglect, that might be a malpractice, if it doesn't fit within the factors in Rule 1.5 and Rule 1.5A and the remainder of the rule, I would try to limit it to the extent possible. But if it's within the factors, I think you have to take the evidence. I would just say try to keep that away from them. You'll be listening to that a long time, and we'll never get done with the hearing if you want to listen to all those side issue complaints.
On the neglect issue, one judge put it very well. We're not here to determine what he didn't bill you for. We're here to determine what he did bill you for.
That's right. And let me just add, this is just a fee arbitration issue. If you decide the fees and you enter a reasonable fee, the client is required to pay it or the attorney refund it, whatever the case may be. But that does not preclude any other issues between the litigants. If for some reason the client wants to then go ahead and go to the ARDC, they can do that. If they think there's malpractice, they can go ahead and bring a malpractice action. The issue is not precluded in the fee issue. And I don't think you need to tell people that's something, go sue them later. But on the other hand, what you're doing, you don't need to worry about it because you are not going to block that issue later on if they want to pursue it.
If you have some serious ethical issue that comes up, please let us know and we can consult with you with our professional responsibility committee if you feel like there's something that you need to discuss with someone else. Yes?
Just want to clarify, David, when you talk about the reasonableness of rejecting an offer, whether it be out of a pretrial or coming out of negotiation with the attorney, I think everyone has to be very aware of the fact that most of the time, reasonable offers are rejected because of the client, not because of reasonable attorneys. I mean, it seems to me, that's what I normally find, that you can present a reasonable offer to your client, but they have their own agenda. Then they'll come back and later on say, no, with the attorney's agenda, you have to be very careful.
You have to be very careful. Sometimes you'll ask the lawyers, where's the letter that says you should take this offer? And you're absolutely right. If it's the client that's rejecting the offer, taking the unreasonable position, that should certainly be a factor that you consider. There is a case out there, and I don't know that I mentioned it, but in re the Marriage of Oriyama, though, that says, you know, the clients wanted us to do this, and everything went crazy because that's what the clients wanted to do, and the appellate court said, no, you have a duty as a lawyer to control your client and to control the litigation, and if you don't, you won't be compensated for it. So there's a fine blend between the two of them.
Yes.
Strictly, you feel we should adhere to the time limitations. What do you say to the client who feels that's not adequate?
The question is, how strictly should you adhere to the 1.5-hour time limit? And then how do you address that with the parties?
I would think you adhere to it fairly strongly. I don't think that unless there's some really unusual issues that the hearing could not be conducted within an hour and a half. If the client is persistent, that the client is not getting its fair share of time, then I think the arbitrators can exercise their rights under the rules, and I'm not sure which one it is. It may be within the order itself, but they can give more time. There's a set rate, and the arbitrators can impose the additional costs on the party requesting it.
That's in the rule itself.
That's in the rule, that's what I thought, in the order itself. And so if they insist, and the arbitrators are agreeable, okay, you can have another half hour, it's whatever it costs under there, and you're going to pay that right now.
Jack?
Before a lot of people leave, I just want to remind everybody to bring reminders next time, or bring a few them, I should have invited to tenants and free, including the real arbitration, interactive action, decision making, objections, or something like that. Even the three of you who work together will come up with an award.
And also one follow-up administrative matter. We've had a request to move the start time a little bit because a third of you will be attending the matrimonial fee committee meeting. So we'll actually be starting about 1:15, 1:20 instead of 1 o'clock. Other questions? Yes.
Shifting situation where one party is like to pay the fee, the other party, part of those fees, is that party bound by the award in the arbitration between the other party and whichever lawyer?
The question is regarding when there's a fee shifting between the spousal parties. How does that get handled?
Well, it all depends on what the parties had agreed to. You'd still just have the contest between the attorney and the client as far as you were concerned. It really shouldn't. That's an area that wouldn't concern you. You give the award and then let the court take care of how it plays out in accordance with the terms of the judgment.
If I could just elaborate on that, there is under our system a separate contribution hearing where that fee shifting issue might be specifically dealt with. So I would